really what's called breaking the app. So for any users who would try to trade in sports event contracts, the app simply would not allow them to do so unless they have updated it. And so if Apple has not released the update to them such that they've updated it themselves, then they're not simply not going to be able to trade, and that's what we call breaking the app. Now, federal regulations require us to keep our market available, but we wanted to prioritize compliance with this court's order, and we did that by giving GeoComply a list of IP addresses that had accessed Kalshi in the past several months, more than 7 million in total. And we asked GeoComply to identify all of the Michigan addresses or addresses that looked like they may have been masking their location with VPN. That's another way of that some folks have used to try to get around restrictions in other contexts. And GeoComply supplied us with a list of, it's a very specific number, but 367 and 420 for 367,420 IP addresses that we should force to break the app if they tried to trade a sports contract. And this was on August 11th, so the day before the as a backup, we got the same residency IP blocks we had in place. We think that's a meaningful sort of backup. It is a federal crime to lie to a designated contract market about your address, and that means no Michigan residents were able to trade, even if they had not updated the app yet. And in the days following, we went even further. We first broke the app with respect to users in states bordering Michigan, and then the next day did it for all 50 states. So we know that has worked in part, Your Honor, because the company has received a large number of complaints from those located elsewhere who are saying, they're just unable to trade and either not understanding why or protesting that they weren't able to. It does put us in a tough position, but we've been, as we've noted repeatedly, we've been prioritizing compliance here with the court's order, and we believe that we are where we need to be with mobile. Now, I'll touch briefly upon API and then happy to address any questions. API, of course, my colleague referenced this, and we've flagged it from the outset, but it is something of a new frontier here. Sportsbooks do not let people use an API to bet, and so GeoComply had to come up with a new process for Kalshi's traders. Again, API is a way of sort of plugging directly into the exchange rather than going through an app or through the web. So the GeoComply essentially came up with a proposed solution to address this. I think this was the first time they had done this before. There were really three components to it. One is with respect to API keys, which an API key is what it sounds like, sort of the key that you have to be able to access the platform through the API, through API access. That will not be issued to any Michigan IP addresses that want to trade in sports. So that's number one. Number two is anyone with an API key, so someone who already has had API access, will have to check in regularly using the app or the website to authenticate their location. So essentially what that means is the geo-blocking that's currently in effect with respect to web and mobile is applied to the API user by virtue of their having to go in through that GeoComply software and identify where they are. And then the third is a GeoComply software that's called GeoGuard, and that monitors for suspicious IP addresses or people who are trying to mask their IP address location. Anyone with one of those has to also complete an accelerated check. So there are two things that are worth knowing about APIs, and then I'll pause. First is people trading through APIs are doing it through physical servers. It's a box somewhere that's not moving. But by forcing the app check-in, we're making sure that the user controlling it isn't located in Michigan. So that's sort of the unique way in which this solution came to be tracking API users. The second, and I want to emphasize this, very few of Kalshi's millions of users access the platform through an API. In the past week, there were 79 users in total, again, out of millions across Kalshi's platform that made a trade through an API from a Michigan IP address. So it's a vanishingly small percentage. None of those trades involve sports because that has been blocked. But in terms of sort of the risks associated with the overall system that we've worked with GeoComply to put in place, API is a very small part of the overall activity. So with that, Your Honor, thank you. That's all I have by way of an update, but I'm happy to answer any questions.
On behalf of the people, do you have any?
Quite a few. So, you guys had the app update was forced to people who are on your IP address list.
The app update, as far as I understand it, was first rolled out. The break feature, update as much as a break of the trading, was rolled out list of IP addresses that GeoComply asked us for the information they believe they needed to force the break with respect to folks located in Michigan, but it wasn't. Very quickly, the day after we did that within Michigan, we did it within surrounding states, and then the next day did it across all 50 states.
So what days were those?
My understanding is it was August 11th that we broke the app in Michigan, August 12th that we did it in surrounding states, and we're able to complete that across all 50 states on the 13th. That's my best understanding. I will correct that if I have that wrong, but.
Okay, so currently we have a situation, Your Honor, where we're getting reporting. We know that Nevada's filed a motion against Kalshi because they were able to place trades with the same blocking software that solution. Kalshi was supposed to be implementing the same solution for Nevada that they did for Michigan.
She's breaking. Just a minute, you're breaking up. Can you just stay closer to your mic and where would you like her to pick up?
Yes, so we know.
Just a minute. Where would you like her to pick up?
They were able to place trades.
Using the same software that they were supposed to be using for Michigan. And we also just received a report today that on, it looks like August 14th in Cass County, a reporter from InGame was also able to place bets on sporting events from Michigan using an account registered to an Indiana address. And so we're continuing to get these reports, and it seems at this point that Kalshi waited until the 11th hour to submit its app update for approval, knowing that it takes time for the update to become available. Kalshi never informed us that they would need more time to comply or attempted to justify a need for additional time to comply. Instead, it allowed that compliance date to pass, claimed that it was in full compliance, and then only admitted the facts showing that it's not in full compliance once confronted with evidence to the contrary. And at this point, they say that the app is updated. I'm not sure whether it actually is, whether the force update has gone out. Well, I hope to find more information on that this week, but as of the 12th, it certainly was not. And that's by Kalshi's own admission that they were not requiring any IP addresses that weren't on the list to update before placing sports bets. And this suffers from the same issue that we identified in the evidentiary hearing. So I mean, ultimately it's your decision whether to assess fines, Judge, but we do not believe that this is what compliance in good faith looks like.
Your Honor, may I respond?
Response, yes.
I just think it's totally untrue that we hadn't rolled out the app update by the 12th. I think I just indicated that following GeoComply's guidance, because Apple cannot force the update across the country, we broke the app and we did it using GeoComply's guidance as to how to locate persons who needed their app updated. And then we did it in all surrounding areas. The situation in Nevada is a situation where there were investigators who we believe had locations that were in other states according to their KYC information, and that is the reason they were able to place trades. But we have broken that as well. But we had, with respect to Michigan, we had done all of this as of the 12th. And just on the point of, I just want to address, because the suggestion that we slow roll this or somehow engage in bad faith, that this isn't good faith compliance. I mean, I really have to take exception to that. We have worked with Michigan's selected licensed geo location service provider, GeoComply, around the clock since the court's order went into effect. We have been working all hours, both our engineers and their engineers, and I can attest to this because I've been on many calls that have been well into the night, getting us into this position. And I firmly believe that a GeoComply representative would testify that the rollout that we were able to do with respect to issuing the updated app to both Apple and Android was done at the earliest possible time that we were able to accomplish it, consistent with the technology.
Response?
So we know that, at least for this article, Kalshi was contacted and told that reporters were placing bets from within Michigan because the app update was optional. And they've known that they were able to break, whatever you want to call it, force the update before you get to trade. Any apps work like that you have to update the app in order to use it. And they chose not to do it. It's as simple as that.
There was no choice not to do it. If anything, the choice here was to create a solution to break the app in a scenario where the update wasn't something that could be forced on users. That's just a technological restriction that we have to act within. And you know, in order to be blocked. That's
Just a minute, sir. You froze, sir. You froze for a minute. Court reporter will tell you where
to arrangement can put in.
Mr. Mainland, just, you're breaking up.
Should I back up?
Sir, you're breaking up. Can we go, you're like you're frozen. Can you go off and sign out again if you can hear me?
Kennedy? We're not on Zoom. Or if we are, we're not recording.
Kennedy? Are we recording? Are we in Zoom? We're in Zoom. She should be signing in. Oh, there he is, yeah.
I apologize. I got dropped.
It's the way technology is. Okay.
Yeah.
So can the court reporter tell you, the court reporter can tell you where to start?
Give me a second here. Pretty much the beginning. There was no choice not to do it. If anything, the choice here was to create a solution to break the app in the scenario where the update wasn't something that could be forced on users. That's just a technological restriction that we had. And you know, the
Okay, so I will take it from there.
Take it from the beginning, pretty much. You just froze. We couldn't understand.
Sure. With respect to this article, all the article confirms is that you do indeed need to update the app in order to be blocked. And when we were getting near the August 12th deadline, when with the potential that the app would not be fully updated, then or with the technological restrictions on ability to force an update, we broke the app using GeoComply's list and GeoComply's guidance. On some level, at the end of the day, the GeoComply service is the expert that we're relying on here, and there's zero effort. And I really take exception to the implication that we're somehow slow rolling this or trying to drag this out so that there could be some like one additional day of trading or something like that. There's zero evidence of that. And I also am, I mean, the article that they reference, I have no idea what the timing was when this reporter suggests he was able to place a trade. But given the date of the article, it seems very plausible that that was on August 12th. And so by the end of that day, we believe we had rolled out the break to all persons located in Michigan. And we haven't received evidence from the state or from anyone else saying an actual trade was placed. They don't have investigators who are claiming to have placed trades. And then the final thing, Your Honor, is just we have been giving the state weekly updates in a great amount of detail, explaining to them what our process has been, the various components of it, the work we're doing with GeoComply. They were completely in a position to ask us any questions they had about that process, to join any conversations they wanted to with GeoComply, to air any concerns they had with respect to timing or any aspect of the rollout, and did not engage with us in that way at all. So now to be saying we've heard of a trade through an ingame.com article after the fact, I just don't think is a fair approach to this whole process. We've been working in utmost good faith.
So you have one person that's reported this or what? I mean, ultimately I'm not going to deal with, he said, she said, we can have an evidentiary hearing on all this. And occasionally there probably will be somebody who falls through the cracks. We just hope there's not many and that those are then refunded in accordance with previous orders. What would you like me to know, ma'am?
Yeah, so I wanted to clarify because there seems to be some playing the blame game going on here. So we start with it's GeoComply's fault, it's GeoComply's list. He also started his with stating that they provided the list to GeoComply. So that doesn't really make sense. GeoComply, the industry standard, is that in order to place bets, you have to have update that allows for geolocation and location services before placing a bet. And this isn't a new concept. This is something that has existed in apps for a long time. So the idea that that's just something brand new that they had to come up with doesn't add up. In terms of the report that we have, basically the way that this is working is that sounds like Kalshi is restricting based on residency, which
based on what?
We already established at the evidentiary hearing that residency and simple IP addresses is not sufficient to identify where someone is located. And that the laws of the state of Michigan apply to anyone present in the state of Michigan, not just residents. So in terms of the article that Kalshi was contacted about and didn't tell us about, include screenshots that have the trade date as August 13th, 2026 at 4:19 p.m. So that's what we know about that. We just found out about this because Kalshi didn't share that information with us, even though the Kalshi spokesperson was contacted.
Your Honor, I don't want to impose on you a ton of back and forth here. I will say it's just not true that we're geofencing on the basis of residency. As I've said, the entire country is now experiencing a break unless they update the app, and the GeoComply software is within the app. So that's just, I can't, it's very hard for me to speak to this one trade that's referenced in one article. But I would suggest, Your Honor, if that's all that is giving rise to, by way of evidence to the state's concerns, that is not significant evidence. I do want to correct one thing I said with respect to whose list it was with respect to targeting Michigan in particular when we were prioritizing breaking the app. And I believe I may have misspoke on that, but with respect to how that list was compiled, we did, and we're not blaming anyone. We have been working with GeoComply, who's an expert who the state demanded we work with. But we did ask them what they needed with respect to trying to come up with a solution that would really prioritize Michigan in those early days. And we gave them a list of all IP addresses that had accessed Kalshi in the past several months. That was 7 million in total. And so the list of 367,420 addresses that GeoComply recommends we use to break the app, that is what came from GeoComply. They called the 7 million to 367,000 approximately, so that we could prioritize breaking the app with respect to persons located, then move out in concentric circles to get surrounding states and then the country more broadly. This is all a creative way of dealing with the fact that you just can't force Apple to force others to have their app pop up on their screen and force them to update it. So that is the process we engaged.
So you are able to monitor both residency and presence. So someone from Indiana comes here, they are blocked?
Correct. And in fact, in the same article that they're referring to, the trader who, once the app had been updated, went back to Indiana, they were able to trade. And were blocked even when they were near the state line or on the state line when they were within Michigan. So we have every confidence that it is currently working, and we believe it was working as of August 12th.
Okay, well, to impose any costs, fines, whatever, it does seem that they've done their due diligence. I know you have concerns, but it will take an evidentiary hearing. You certainly can, everybody can come to my courtroom and we can have an evidentiary hearing. Is that what you're requesting, counsel?
I don't know that we need to have an evidentiary hearing at this time, but we're definitely still have a lot of concerns on whether it's actually implemented.
Well, we can keep having these hearings and you all can keep gathering information, going back and forth, and then if it comes to the point over the next few weeks that it's not working and they haven't responded, then we can have an evidentiary hearing. With all the work that they've done and the technology, and there's no evidence, it's what you all believe or read or were told or your understanding, I cannot impose a fine based on that. If you are asking for a fine, I need the evidence from both sides, the experts here, and then I will make a ruling based on evidence, not the beliefs of all of you. So this is new. It looks like they have significantly, if not 100% compliance, right up there. And technology, look, this morning I struggled getting into my kids' school program, and they've been going to the same school for decades now. And so you know, for some reason, it's not working. It's working on my son's app, it's not working on mine, it's not working on my daughter's app. It's the same program, so there are glitches. I call the school, it's crazy. Okay, so I say that because we've all run into those problems. So with this massive implementation, if there's going to be a bug here and there, and what we're looking for is compliance, and it looks like they've significantly complied. We need 100% compliance with our law, but I don't have any evidence that there's been a consistent breakdown. And it looks like they're monitoring and then sealing up whatever falls through the gap. So why don't we continue meeting for a few more weeks? You continue to see what gaps there are, and then if there's no compliance, we will have that long evidentiary hearing with experts, evidence, documents, all the things that you lawyers know how to present to the court.
May I ask one thing, Connor?
I'm sorry?
May I ask one thing separately?
Yes.
Will you be addressing the PI motion today?
The API motion, is that what you said?
The preliminary injunction?
No, I'm not adjusting it.
We-
There's no request to do, I mean,
we
why do
don't-
I need to adjust it?
Oh, I'm sorry, Your Honor.
What,
We had a
Well,
similar question, which was that I think Your Honor had indicated at the time the TRO was entered that eventually a formal preliminary injunction order would be issued once the geofence was implemented. And with that, you know, we, at least on the Kalshi side of things, were wondering whether it was still the court's intention to issue sort of a final PI order, so to speak, which could have appellate implications for us. So,
right, so, I mean, we can do a permanent one. I didn't know if you wanted to, with these allegations of breakthrough, if we want to keep it open a little while just to see what's going on. Otherwise, I can turn it into a permanent injunction. On behalf of the people, what are you asking specifically?
The people would request the injunction be entered,
Be what?
that the injunction be entered.
A permanent one.
I guess my only question on permanent is, you know, typically, at least where I'm from by way of practice, like there's a preliminary injunction, and then after a trial on the merits, a permanent injunction may be issued. I understood that
You're breaking up.
state would seek a temporary injunction,
Sir, you're breaking up
and
again.
the issue right now is just no. Can you hear? No. I will hang up and then dial back in.
Okay.
Can anyone hear me now?
Yes, so, well, what? I'm looking at the orders right now. What, can you two agree on an order and present it to the court?
Sure, we will meet and confer on that.
Great, why don't we do that, and then, do you wanna continue meeting as I've suggested, or call it good and you can go to the appellate court?
We are happy to take the court's guidance on whatever will be helpful. We believe we're in compliance and believe that we're in a good spot, and yes, we do intend to go to the appellate court.
I think, no, I take no offense. It's I wish them good luck. We've had all sorts of states watching this, but the state has the power, so that's how I operate under, so. On behalf of the Attorney General, you can work with them on that, and would you like to continue monitoring this? I know you have some concerns.
Yeah, I think it would be helpful to continue monitoring,
All right,
that we don't know at this point.
all right, so we'll meet next Monday at 10, before then, the two of you will meet and give me whatever order you can agree on. If you can't, then each of you will present your proposed orders, and then I will come up with what I think is reasonable. Is that acceptable?
Yes,
Yes,
Your
Your
Honor.
Honor.
Thank you.
Great, thank you. I'll see you next Monday at 10. It's all
Thank
for the
you.
record.
Yeah.
Oh, wait, is next Monday is not a holiday. I think it's the Monday after that. Okay. We're good, right?
We
Yeah.
have one, is there one on here? We need her appearance. Is she on this one, Valenti?
Oh, Ms. Valenti is my colleague from the Milbank firm, who I believe has entered an appearance, but if not, we can take care of that.
Okay. So I will see you all the, 24th, right?
Thank you very much, Your Honor. That's right.
Thank you. I'll look forward to that order.
Thank
It's all
you.
for the record. Okay, next.
Brandon Trevino, V Secretary of State, Your Honor.
All right, this is docket 263349 AL Juan Trevino versus Michigan Secretary of State. Counsel, your appearances for the record.
Good morning, Your Honor. APA Bart Bucks, and on behalf of the people of the state of Michigan, representing the Secretary of State.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Mr. Trevino, who is my right. Mr. Trevino, please state your name for Your Honor and the court to know at issue.
Juan Trevino Jr.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, the whole truth, and nothing but the truth, under penalty of perjury?
Yes.
Thank you. Put your hand down. Are you taking any medication using marijuana alcohol yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And on behalf of counsel, you are requesting a
Hardship license, Your Honor.
hardship license, yes. And it looks like he has been free of alcohol, crimes, whatever, for 10 years plus.
That's correct, Judge.
On behalf of the people,
Yes, Your Honor. The hardship restricted license would be granted under 25.323C. I just want to point out in that statute, it states the court shall not order the Secretary of State to issue the restricted license unless the person states under oath and the court finds that the person is unable to take the public transportation to and from his/her work location, place of alcohol or drug education or treatment or educational institution, and does not have a family member or other person able to provide transportation. So I just ask that those questions be asked on the record, and that if a restricted license is granted, it be granted under this statute. Thank you.
thank you. Counsel, would you like to address these things?
I do. Well, I'm going to ask you some questions. You did hear what the prosecutor said, correct?
Yes.
Okay, is it true you are a caregiver for your parents?
Yes.
Your Honor, if you could swear him in prior to questioning.
Didn't I just swear you in?
She swore him in.
Oh,
to start
I
the hearing?
apologize, I missed that.
Okay.
I apologize.
Okay,
Sorry.
so we're good?
Yes.
Okay. And is it true you're a caregiver for your parents?
Yes.
And is it true you are the only caregiver for your parents?
Yes.
Okay, is it true you have a full-time job?
Yes.
And is it true that between caregiving for your parents
Is it
and
true that what?
between caregiving for your parents, sorry, Jersey accent, between caring for your parents and working full-time, that public transportation would be a major hardship?
Yes.
Would you likely lose your job?
Yes.
Okay, do you need the license to also get alcohol and drug treatment?
Yes.
Is it true that you've been compliant for a long period of time?
Yes, I have.
Do you understand that if your honor grants the license, it would only be to go to work for medical treatment and for alcohol treatment?
Yes.
Do you understand you can live with those restrictions?
Yes.
Judge, I think that covers the requirements.
On behalf of the people, any questions?
No, Your Honor, thank you.
All right, court is, based on his responses and what I've read, going to grant the hardship license, and he'll be able to drive for work, school, medical, court.
Thank you, Judge.
And his parents' needs as part of his job, so it'd be not just his other, you have other employment as well, correct?
Yes,
And then you're also caring for your parents?
yes,
Okay, so in caring for his parents, he would be able to pick up their medication, go to Myers and pick up
Doctor's appointments and
those kinds
such.
of things for them. So it doesn't mean you get a free ride around everywhere you wanna go, but you'll be able to drive for both jobs.
yes, that's the most important.
Okay,
Yeah,
Thank you, Judge.
okay, you'll prepare an order?
I will, Judge.
Thank you very much.
thank you.
Okay.
Red Bull explains.
You want?
No.
You gotta
I'll bring Kittle out. When you see your Kittle next? He's in custody, Your Honor, he's being brought out right now.
I know you said don't ask if you need a Red Bull, so I can't talk fast enough.
You can't have Red Bulls.
No,
No, well, then
And
it's.
you talk getting fast, it's a whole courthouse. No. All right, this is docket 24470FH, People of the State of Michigan versus Skeeter Willie James Kittle. Counsel, your appearance for the record.
Good morning, Your Honor, APA Bart Buxton on behalf of the people of the state of Michigan here at probation.
good
morning.
morning.
Good morning, Your Honor. Agent Barr with probation.
Good morning, Your Honor, Assistant Public Defender Stephen Feigels on behalf of Skeeter Kittle standing to my right there.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
Thank you. Put your hand down. And let me just see which one of these are we on, the one that was dated 4/10?
Yes, that's correct, Your Honor.
All right, and he was previously arraigned.
Yes, Your Honor.
All right, and sir, just by way of reminding you, the allegations against you are count one, on or about April 5th, 2026, defendant assaulted Samantha Connell, Connell. Count two, on or about April 5th, 26, defendant had contact with Samantha Connell, Connell. In violation of personal protection order. Have those matters been resolved, or are there more allegations?
Judge, those matters are pending in Eaton County. They're gonna be resolved next month, but I do think we've worked something out where we can address this without impacting the case in Eaton County. If we make an admission to count two and the dismiss count one, I don't think we'll be able to move us through this without impacting the case in Eaton County.
How is that? I mean, if he's gonna admit to being with her, that goes to one of the elements in regard to count one. Are you going to trial on that?
Are you gonna try on?
Oh, heck no. Why, because he's not pleading to this. What's the issue here? What else can we do? I'm not, if he pleads to violating the personal protection order,
Which I think he's already been sentenced on, Your Honor, is that correct?
you got thrown out.
Got thrown out.
if it got thrown out, why is he pleading to it? Here's the problem, if you got thrown out, why is he pleading to it? Second, if he pleads to it, they could reissue it, I suppose, or they'll use it as he was clearly within her vicinity and then had the ability, based on this personal protection order, which you knew you shouldn't have been, to assault her, and there's history and, I mean, no. I mean, if you wanna step on your rights, that's what you can do, but counsel, I have trouble.
Fair enough, Judge.
So what's the issue here? Is he in our lockup or?
He is in our lockup, Your Honor. He's been in since April. That's part of the issue.
Yeah. So what's going on in the other, do you have a bond in the other file or what?
They gave him a PR bond in the matter of Eaton County.
Yeah. So the question before this court, as I'm going to deal with it, is a question of bond. So would either one of you like to address bond?
I would, Your Honor. Mr. Kittle does have a pending matter in Eaton County, which is the stem of this violation, at least with regards to count 1. Your Honor, he does have a PR bond in that case. I believe he's set for trial September 10th or September 11th. September 10th, Your Honor. So there will be a relatively speedy resolution to that case sometime September, October. I asked, he's been in custody on this matter since April of this year when we came for an arraignment here. The court adjourned it out to allow the other matter in Eaton County to work itself out. Your Honor, I ask that he be given a PR bond and we can set the matter for proceeding in October or November this year.
Does he have a current address? I have the 291 Cambridge Drive. Is that still current?
Yes,
Who lives there?
me, my son, Samantha,
You can't go there. So where are you gonna live?
that, do it,
Okay, what, under a rock? I need an address.
yes, I'd have to get it from my books.
So you with your parents?
No,
Where would you reside?
it's a friend,
Does that friend have a criminal history?
no.
And is that at least 500 feet away from them?
Yes,
On behalf of the people?
Your Honor, could I at the very least get the name of this friend that he's
Well, we're
supposed
gonna
to
have it
be?
verified. He's not gonna be released until all that happens. So what is the name? Do you have a name?
yes.
What?
I'm sorry.
Okay,
Cassandra Curtis.
a woman?
Sorry, I'm nervous. Yes,
And, no,
you said no?
no.
Your Honor,
Here's the problem. If you're gonna live with a woman, you're gonna go through domestic violence treatment, et cetera, et cetera. No.
Well,
What
it's-
happened to your parents?
I haven't spoken to my parents in years.
Okay, do you have any male friends?
Yes, it's her house. She stays there with her husband.
Alright. Okay. I'm not going to release you until there's an address verified with an appropriate person, and I will have probation verify that. You'll also have a GPS tether. On behalf of the people, anything further?
Your Honor, I believe probation wishes to be.
They do, I see that, I know that, but I'm asking you.
Yes, Your Honor. The only other thing is looking at his criminal history, and this is just based off of his current case. He had 4 felonies, 6 felonies and 4 misdemeanors, Your Honor. They appear to be, pulling them up. I'm seeing an assault intent to do great bodily harm from 95. I'm seeing a DV from 96. I'm seeing a DV from 97. I'm seeing an assault with intent to rob from 97. DV from 97. Your Honor, I'm seeing a pretty assaultive history.
That was 30 years ago, Your Honor, or close to 30 years ago.
I'm seeing some as recently as 2010, 2013, 2014, 2015. All of these are assaultive. I'm seeing a 2016 assault with a dangerous weapon, 2017 assault, 2017 assault, 2017 assault with intent to do great bodily harm less than murder. Your Honor, this is a pretty violent individual. The people are concerned that if released, the defendant would be a danger to himself and others.
All right, thank you. On behalf of probation.
Your Honor, that's exactly what I was gonna state, that he has an assaultive history since 1995, and the pending matter is DV, 3rd offense. And regardless if the PPO violation was dismissed, that doesn't mean that we're going to dismiss it. I did speak with Attorney Feigelson briefly. I'm covering for Agent Kirchen, but while looking into this, with him not even knowing who he would potentially be staying with, again, that's a huge concern, and I know your honor understands that. So if we do verify a residence, I would still ask that there is a bond in this matter, your honor. Thank you.
Judge, a couple of things I'd like to add. I know he's got a criminal history that's indicated that, but the last charge was almost 9 years ago, Your Honor. He did, in the matter that's involved in this case, he kind of gave him a PR bond, who may know the facts better than we know. So I think those are the two things where I think the PR bond would be appropriate. He is going to be able to stay away from Miss Connell. He is going to be able to stay with the husband and wife, people that he knows, people that he trusts, people that can keep him on the straight and narrow and get him not only to his court case in Eaton County, but his court case here as well, whenever the court's ordered to set any date.
Well, he needs to keep himself on the straight and narrow. No one's, unless they're leashed to him, they're not his babysitters, and so he's not gonna be with them all the time. So, another question for probation, do you know if he's gone through any anger management or when the last time he was positive for drug tests?
Your honor, he was sentenced in December of 24. He reported employment and he's made a couple payments towards some restitution. And then April 24th, 26th, MRT was ordered, probation was extended.
But you do want to know this, the charge that he's here in front of this court is a larceny in a building, so I don't even know if they would have ordered domestic violence classes.
So I don't see that the DV programming was ordered, but we can absolutely add that, your honor.
But they may add that in Eaton County, depending on what happens there. There's no reason to do both. Still let Eaton County address those issues here.
So you are married to Ms. Connell?
She's my partner. We've been together 13 years.
Okay, and you have children with her?
One son,
How old?
10 something.
Okay, so you are not able to see your son? You understand that? Are there family court orders?
Excuse me?
Are there family court orders? Is there a judge who has put in some parenting time? Is anything pending?
No.
Is that something you're gonna petition for?
I haven't put thought towards it. I don't know how I do it, if I didn't think I would need to do it.
Well, is your name on the birth certificate?
Yes,
Well, you have
yes, I
a
take
right
it.
to parent him, but you may get supervised parenting time, but when was the last time you saw your son?
Maybe 3 weeks ago. I don't know, on a video visit.
Okay, so, okay. How did that happen? Was that through the mom? Or is he calling you?
Yes.
So that's through her? Is it yes?
Yes.
Have you been calling her?
Samantha, yes.
There's a no contact order, ma'am, or sir, what?
Your Honor, my understanding is probation just talked to the people in the back, and I believe Samantha Connell is here at the back of the courtroom, Your Honor.
Oh, all right. Counsel, have a seat. Did you wish to address the court, ma'am? Did you wish to address the court?
I'm just here to support.
Would you mind coming up here so I can talk with you? Sorry to put you on the spot. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and nothing but the truth?
Yes.
Thank you. Put your hand down. Come a little bit closer to the podium. Okay. Please state and spell your name for the record.
Samantha Connell, SAMANTHA, CONNELL.
So, ma'am, You brought your son here, so he knows about all this? I don't know that that's in his best interest, but, okay.
Not details, he just knows his dad is been away.
And now he's seen in handcuffs. Your parents, your decision. Tell me about what's happening here. Are you planning on living with him again?
Yes, eventually, yes.
Okay, and you understand I saw the no contact order in place?
Yes,
So that means that he's not supposed to have contact with you directly or through another person. I understand if you dial the phone for your child and he does the call. But ma'am, you're not, there's no contact order. You feel safe around him?
yes, I do.
Are you aware of him using alcohol or illegal drugs?
No, it's a present father and has been in his son's life.
So is there a grandparent or someone else who can supervise parenting time?
Yes,
Who?
his grandma on his dad's side.
And do they have a good relationship?
Yes,
What's your son's name?
Rome,
How do you spell it?
Rome. Last name Kittle.
All right, so I'm going to allow a third party to arrange parenting time, transport, and be present for parenting time with your child. That means that grandma has to be there at all times. You can talk to grandma, you cannot talk to him. I'll be violating my order and you can go to jail.
Okay.
So if there's information that needs to be transmitted, it will be done through a third party that you approve. Right now, you've approved his grandmother?
Yes,
Okay. And if something does happen, you become aware of it, are you willing to report that to the court?
yes.
All right. Hey, anything else you want me to know?
That's all. Thank you.
Okay, thank you. We don't have a next court date here. Here's what I'm going to do, counsel, if you approach. Sir. Oh, I didn't mean it. I'm sorry. I said that poorly. Okay.
I thought that's.
Yeah, I know, sorry. Okay, so, sir, here's the thing, I want everyone to pay attention to this. Because they're going to remind me, sir. If you violate my orders, I really just don't care about any more violations. If you violate after me doing this, then what I'm going to do, sir, let's see your guidelines for 5 to 23, I can go over those, I can find that you're a danger and you didn't give a crap, and if you don't give a crap, I won't either. So you have a 4-year felony, so that is, let me see, 48 months, so I could sentence you to 32 to 48 months, how's that sound?
Doesn't sound too good.
Well, then get everything in order. We need to be our best citizen, not have all these violations. You already got a break on this file, you pled, there's a plea agreement. You know, you had a habitual, it could have been so much worse, sir. You had a 10-year felony, could have been a 20-year. You got a 4-year, deal of a lifetime. So I'm gonna let you out on bond. I think you served enough time, you need to prepare for your other case. You have our top probation agent here. She has my phone number, as do they all, can call 24 hours a day and I will sign a warrant. One step out of line is 2 steps into prison, got it? Great. I'm giving you a $100,000 PR bond to report to probation weekly until directed otherwise. Now, I don't care if it's a combination of in person, on Zoom, on phone, you just listen to whatever probation wants and comply. You'll be placed in a jail GPS tether with victim notification. You will not use, possess, consume, or be in the presence of any illegal drugs, alcohol, or drug paraphernalia. You'll show off prescriptions for medication from a licensed medical physician to pretrial services within 24 hours and take any psychotropic medication, if any, as prescribed. You'll follow all doctor's recommendations. You will PBT and or drug test 3 times per week. And that is Monday, Wednesday, Friday. Actually, it's 4 times per week, I'm sorry. Until I am satisfied there's nothing else going on. So it's gonna be Monday, Wednesday, Friday, random on the weekends. If you're using, you're back in the slammer. There'll be a secondary test if you're positive to verify that it was a positive and not a false positive. And you will test as requested by probation, law enforcement, any court officer or adult you reside with. You will not have in your possession or under your control any weapon, gun, ammunition, indication of a weapon. You'll not be in the presence of anyone who has those items. You will maintain your residence after there's address verification with an appropriate person. So I don't know who that's gonna be, but probation shall approve and advise the court and counsel. I've already told you about the third party. Right now it's gonna be grandmother. I'm gonna put grandmother or other person approved by probation. And the child's mother. You'll not have any contact with Samantha Connell. Was there a victim on another file I need to add here? Okay. And you'll attend community mental health and begin anger management treatment or as directed by probation. You'll re-engage in probation and comply with all probation orders. Anything I missed on behalf of probation?
Your Honor, I would just like to have the grandmother's name on record, please.
What's your grandmother's name, Mr. Kim?
Joe Gittles, J-O-A-N. Can I switch the residence to my brother, Jeremy Kittle?
Remember, I just put after the residence is approved to talk with probation, give her whoever, brother, sister, whoever. This isn't the neatest order I've ever done, but it's there. Best behavior, sir.
Judge, do we need to get a date for the hearing or does this satisfy that?
I'm not gonna deal with the hearing. What I would ask you to do is after date. I don't know what's gonna happen in Eaton County.
That makes no.
So how about after Eaton County?
Can I have them contact you after I know what's.
Let me just give you a date so we don't fall through the cracks, and then you can change it based on what happens. Kind of do it that way. So let's have a date of,
If the trial's September 10th, it should be probably near the end of September.
but then he's gonna have to be sentenced too. And that should probably make sense for what we do. Right, so. November 4th at 11,
Is that a Wednesday, I assume?
yes.
I'll make that
Give
work.
them a purple notice, November 4th at 11, it'll be a probation sentencing. And status. And then we'll make sense of whatever the county did. Best behavior, sir.
I think you've got too much.
Sorry, which one? Sean? I don't know. I haven't heard.
No, and that's not how you. Okay. It's just not showing.
About 285.
Mrs. Johnson?
Yes, Your Honor.
This is docket 25-1992 FH, People of the State of Michigan versus Michael Antron Johnson. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barb Luxon on behalf of the people of the state of Michigan, Keyworth Probation.
Good morning, Your Honor, Dick Fleming with Main County Probation.
And just a clarification, Your Honor, I think we should also be calling 26-3314, which is also set for sentencing today.
Okay, so they didn't do one. Investigation report, they did two?
No, the 25, Your Honor, is a probation violation, the
Oh,
26
I
is
got
the
you.
PS.
Okay.
Sentencing.
Just look at the files are reversed in front of me. All right. So this is also 26-3314 FH, and that's for the sentencing. The other one is for the probation violation. Okay, got it. Thank you. Counsel, your appearances for the record.
Yes, good morning, Your Honor. Assistant Public Defender Jacob Riley, appearing on behalf of Mr. Johnson.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No, Your
Are you
Honor.
supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And I have a probation violation on or about June 14th, 2026. Defendant engaged in assaultive behavior toward Alyssa Mix. Count 2, on or about June 14th, 26. Defendant had contact with Alyssa Mix. On or about June 14th, 2026, defendant engaged in assaultive, abusive, threatening, or intimidating behavior by physically assaulting Alyssa Mix. Count 4, on or between June 15th, 2026 and June 16th, defendant had contact with Alyssa Mix. Any amendments to this?
No, Your Honor.
And then I also, and that was on the docket that is 25-1992 FH. Now on 26-3314 FH, you pled guilty to domestic violence and or knowingly assaulting a pregnant individual, third offense, punishable by 5 years. Do you recall that, sir? All right, and let me just, this is the file that came out of, or I'm sorry, this probation violations came out of this file.
Correct, Your Honor.
All right, so as to the probation violations, sir, you were on probation with me for what I just read earlier, domestic violence and or knowingly assaulting a pregnant individual, third offense, punishable by 5 years, and stalking, a misdemeanor stalking, punishable by 1 year. Do you recall that?
Yes, Your Honor.
So if I revoke probation, I can impose contempt, 93 days, and or $7,500. I can sentence you under what I had told you, which I think I told you I would do it 365 days, and I give you credit, but I could also send you to prison on the 5 year. Do you understand all that?
Yes, Your Honor.
All right, and how are we proceeding on this?
Your Honor, my client is prepared to admit to those violations.
Is that correct?
Yes, Your Honor.
Did anyone force, threaten, or coerce you?
No, Your Honor.
Anyone promise you anything?
No,
You made this decision after you consulted with your attorney?
Yes, Your Honor.
You've been satisfied with the representation of your attorney?
Yes, Your Honor.
As to count 1, on or about June 14th, 2026, engaging in assaultive behavior toward Alyssa Mix, how do you plead?
Guilty.
As to count 2, on or about June 14th, 2026, having contact with Alyssa Mix, how do you plead?
Guilty.
Count 3, on or about June 14th, engaging in assaultive, abusive, threatening, or intimidating behavior by physically assaulting Alyssa Mix, how do you plead?
Guilty.
As to count 4, on or between June 15th and 16th, 2026, having contact with Alyssa Mix, how do you plead?
Guilty.
And sir, you understood there was no contact order?
Yes, Your Honor.
You were not to have any contact with her?
Yes, Your
And
Honor.
you were also not to have any abusive or assaultive behavior with anyone under probation. You understood all of that.
Yes, Your Honor.
And not only did you have contact with her, but you ended up assaulting her, is that correct?
Yes, Your
And
Honor.
how did you do that?
Grabbing her hair and putting her against the concrete.
And that was not done in self-defense, is that correct?
Yeah, yes, it was, because she tried to bite me at first, but yes,
So she tried to bite you and you could have withdrawn and walked away, but instead you grabbed her hair and put her toward the cement
yes, Your Honor.
much more aggressively than what she did to you.
Yes, Your Honor.
Any additional questions, counsel?
None from the defense, Your Honor.
All right. I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made. He clearly knew the terms and conditions of probation, and none of this would have happened had he stayed away from her. This also resulted in criminal charges being filed, that he also pled to domestic violence, third offense, a 5-year felony. Therefore, these four counts will enter under probation violation. And what is the recommendation of probation?
Your Honor, probation would recommend revocation of probation. Due to his history previously being on probation, we just don't think he's a good candidate for community supervision.
On behalf of the people?
Yes, Your Honor, I was planning on making this argument in the sentencing as well, but I would also ask for revocation of probation and have him sentenced at this time. Looking at Mr. Johnson's criminal history, this is the 5th charge that Alyssa Minks was the victim on, that Mr. Johnson has gotten charges on. I can go in a bit more detail on the PSI, Your Honor, but this most recent case was Alyssa Minks. The one that he's currently on probation for is Alyssa Minks. There was a case back in February of 2021 that was Alyssa Minks. I'm seeing a case from April 10th of 2023 where it was Alyssa Johnson prior to her name being changed to Minks. And then January 29th, 2023, which is also Alyssa Minks. The people are concerned, Your Honor, that Mr. Johnson is not taking this seriously. Despite whatever probation he is on, he continues to have contact with Alyssa Minks and is clearly a danger to her as he continues to assault her and get charges based on his contact with her. So I would ask for revocation of probation and for him to be sentenced on the guidelines 425-1192, which are 14 to 29 months.
Do we need an updated pre-sentence investigation report for that, or can we use this pre-sentence investigation report on the other file?
I think we can use the one on the other file, Your Honor.
Counsel, would you agree with that?
I think that substantially that yes, we can use the other file.
All right. And counsel, what would you like me to know on this?
Well, Your Honor, I think my client would admit that he has not done well on probation. We will not argue against revocation. I would simply ask that any sentence he is given on this probation file be concurrent with the sentence on his other felony case that is scheduled for sentencing today.
Sir, what would you like me to know?
I take full responsibility for my actions and that I take full responsibility for my actions and I hopefully succeed more in life.
If you want to succeed more in life, then you have to put some more effort into succeeding. You have to put all your effort into criminal behavior. You are 24 years old, and I'm looking at this pre-sentence investigation report. And you didn't have a juvenile history, but the minute you turned an adult, you end up in front of courts 11 times. And there's retail fraud, domestic violence, assault or assault and battery, domestic violence, assault with a dangerous weapon, domestic violence, interfering with electronic communications, domestic violence, assault or assault and battery, assault or assault and battery, assault or assault and battery, domestic violence, assault with intent to great bodily harm less than murder or by strangulation, assault or assault and battery. And then another domestic violence, Another domestic violence. Assault with intent to do great bodily harm, less than murder, domestic violence, stalking, aggravated, interfering with electronic communications. Assault or assault and battery, stalking. And then finally, the one that we're here on for sentencing, which is domestic violence, third offense. What are you mad about? You just hate women? You
No,
think you're above every woman you know?
no,
You hate people in general?
no.
Something happened to you? Why this at 24 years old?
Never had a role model, Your Honor.
You know what? Role models are everywhere. One of my role models might surprise you. Try to guess who it was.
Your mom?
My parents were okay. Not everybody has a good mom. I assume maybe, where's your mom?
Homeless.
Okay, so you didn't have a good role model as a mom. Okay. But generally, kids look at their parents and they may say, I want to be that, or I don't want to be that, or whatever. So outside the home, people find role models, good or bad. When I was about 12 years old, I decided my role model was Cher. I didn't know Cher. But why did I look to Cher? Because she was a strong, independent woman who didn't take any crap and didn't take no for an answer. She also did things lawfully. And I admired the strength that she had. You can find a role model anywhere. Television, a superhero, your next door neighbor, a fireman, someone in the grocery store who you see helping someone, working hard. They're all around you. Have you never looked at other people and said, I want to be this person or that person? Because it looks to me like you've looked at people and said, wow, that guy's strong because he's got a fist in a woman's face. That's backwards, sir. There's no role models that you could think of. Not even a superhero. Is there one?
No.
Why is that? You didn't have a teacher you liked, a principal, a coach?
Cause I feel like everybody, mostly my friends or my family basically neglected me as a child.
Okay. So there it is, sir. It's not that you didn't have a role model. It's that you have felt like a neglected human who deserved better. And so you're angry and you are taking that anger out on everyone. There it is, sir. Have you ever been in counseling?
No, no.
These 11 times you were in front of a judge, no one put you in counseling? I believe I did. Didn't I put him in counseling?
Yes, Your Honor.
Did he participate?
This last time, no, Your Honor, he violated, almost right after being sentenced. But previously, he did participate in a DV program through,
Try cap.
And did you pay
Okay.
attention?
Yeah,
What'd you learn?
basically more like that. I mostly learned how instead of getting mad to walk away, but then it de-escalated by me getting more angry than instead of walking away like I should have.
Here's my thought pattern, sir. Your guidelines on the new case, which we'll talk about in a minute, are 12 to 24. And the other case, the one with probation violations, your guidelines are 14 to 29. I have to decide, which I will decide in the next few minutes here, once we go through the other file, I'll sentence you on both at the same time. Whether you do a year in the county, which isn't a year, which is troubling to me because you need the time, or you go to prison. How do you feel about that?
Shameful.
It is shameful. Regardless of what happened to you as a child, essentially you're back in that place being angry. You haven't asked for help. And you're a man now, you're 24, your brain's still developing, but in another year or so, your brain's gonna be fully developed. You should have reached out and asked for help. Look to find somebody, participate in all the treatment. All these times you were in front of a judge, treatment was ordered. Lots of things were ordered. You have to help yourself. You have to be your own hero first. Be the role model you want to be, instead of being a good felon. You don't deserve to be in prison. You don't deserve to be in jail. But that's exactly what you have bought yourself by your own behavior. So I'm gonna hold up on the sentencing until we do the next file. We're now on docket 263314 FH. And sir, I already told you this was domestic violence, punishable by 5 years. Have you had an opportunity to review the pre-sentence investigation report?
Yes, sir.
And you spoke about this with your attorney as well?
Yes, Your Honor.
Corrections, additions, deletions on behalf of the people?
Yes, Your Honor, on both the cover sheet as well as the basic information, the sentencing date says August 18th. Obviously, it is today's date, so it should be changed to reflect today's date, the 17th.
And so what about the jail credit days? Is that, so it would be 64 instead of 65?
The jail credit days are correct, Your Honor,
Okay, then let me
as it
just,
does say 8/17 there.
okay. We just changed the sentencing date then. I've got that on the basic information sheet, cover page.
It
Instant
appears to be
offense.
correct on the report itself, Your Honor.
Okay. Let me check instant offense.
Instant offense actually does need to be changed, Your Honor.
Okay. Any other corrections?
The only other thing, Your Honor, is 10 of 11, which is the probation case that you had just dealt with, Your Honor. In
Yes.
the narrative, it states he was scheduled to appear before the Honorable Judge Stokes on 8/18. However, the case was reassigned to Judge Aquilina. The date has yet to be determined by the court as of 7/30/26. I believe that's actually, that portion is in relation to number 11. So I think that can be taken out at this time and be replaced with sentencing for the probation violation will occur. Well, I guess.
All right, I'm just gonna leave it alone.
Okay.
So so it must have been
So I believe,
randomly assigned to him and then given to me because I had the prior case.
I believe so, Your Honor.
Okay, got it. Okay, any other corrections?
That is it in regards to the body, Your Honor.
Counsel, any corrections?
None from the defense, Your Honor.
Thank you. How about ESER scoring?
Yes, Your Honor. OV3 is currently scored at 0 points. OV3 is physical injury to the victim. When looking at on page 3, that specifically states a description of the offense narrative. It states, Your Honor, that she declined transportation to the hospital after being evaluated by Lansing Fire Department, but reported pain to the left side of her face. Your Honor, I do believe that OV3 should be scored at 5 for that, which would be bodily injury not requiring medical treatment, as she did experience pain in her face due to the defendant slamming her down on the concrete.
Response?
Your Honor, I discussed these requested changes with the prosecution. I will not object. I believe your facts
Court
are correct.
agrees. So the total is 30 unless you have any others.
I have one other, Your Honor,
Okay.
that I have discussed with defense. OV19 is currently scored at 0. OV19 is interference or threat to security. So OV19 is currently scored at 0. I believe it should be 10, which states that the offender otherwise interfered with or attempted to interfere with the administration of justice or directly or indirectly violate a personal protection order. In regards to that same description of the narrative, Your Honor, at the bottom of page, in the middle of page 3, on the 3rd paragraph, it states, officers subsequently located the defendant walking nearby. Upon observing law enforcement, the defendant ran before being apprehended without incident. Your Honor, as the defendant tried to run prior to police contact, I do believe that OV19 should be scored at 10 points.
Response?
Your Honor, I think it's arguable, but I will not object to that change. And
OV19 is 10, total is 40. What's the
Correct.
range?
That would make the level 4, Your Honor, and that would make the guideline range 14 to 29.
Change basic information sheet and doesn't look like I need to change anything in the narrative.
I would agree, Your Honor.
All right. All right. Any other corrections?
Not from the people, Your Honor.
Counsel, do you have anything else?
No, Your Honor.
All right. Is there a victim here?
I don't believe so, Your Honor.
All right. What would you like me to know?
Yes, Your Honor. I understand that the recommendation of probation is the 365 days in the jail with credit for 65. However, Your Honor, based off of the now current changes to the guidelines being 14 to 29, and with defendant's current case of 25-1992-FH, also having a guideline range of 14 to 29, I do believe that time in the Michigan Department of Corrections would be appropriate, Your Honor, given everything that's happened here. Mr. Johnson has continually had contact, and not only regular contact, but assaultive contact with Alyssa Miggs. The defendant already on 25-1992, prior to this offense of 614, already had contact with her and admitted as such. And as I had stated during my argument in regards to the 25-1992 resentencing, the defendant has had criminal contact where Alyssa Miggs was the victim in numerous cases, Your Honor. Obviously, the current offense, the 11 of 11, in the 10 of 11, that's on the PSI, in the 9 of 11, Your Honor, which is 25-588-FY, which was from February of last year. Then there is the incident that is 7 of 11, which is the interfering with electronic communications. I understand that that was dismissed, but that was dismissed as part of a global resolution with other counts, Your Honor. And she was not Alyssa Miggs at that time, she was Alyssa Johnson. And then number 5 of 11, Your Honor, that happened on January 29th of 2023. She was also, Alyssa Johnson was the victim in that matter, Your Honor. Mr. Johnson cannot stop interacting with Ms. Miggs, despite probation, despite going to various programs to hopefully address his anger management and domestic violence tendencies, he continues to violate with the same woman over and over and over again, Your Honor. So I would be asking for a Michigan Department of Corrections sentence on the higher end of those guidelines, Your Honor. Thank you.
Do we have probation, any comments?
No, Your Honor.
On behalf of your client?
Your Honor, I do agree that clearly my client needs to avoid any further interaction with Alyssa Mix. I think he would even agree with that at this point. And he has had several cases that have gotten him to this point where he's looking at these sort of guidelines. However, I do want to note that, as you mentioned, he's 24 years old. He's someone who I think still has an opportunity to be a productive member of society. He needs correction, he needs guidance. I think that's something he has lacked, frankly, his entire life. And I don't see a term of in the Michigan Department of Corrections as likely to have a positive effect at all. I think, frankly, keeping him at county, putting him through whatever programming assistance they have locally is a better option. And I would ask that the court adopt the recommendations of the pre-sentence report.
Sir, what would you like me to know?
I'm just really, I'm ashamed for, I feel ashamed for myself. I never wanted this to happen. I was getting too many chances back to back. Nothing changed. I just feel so ashamed of myself right now for everything.
What's with you and Ms. Mix?
It actually first started when when I caught my first DV with her, and she accused me of hitting when she was with her boyfriend, her first boyfriend. She accused me of hitting her when she spent the night at me and her cousin's house. She accused me. We got into an argument, didn't touch her whatsoever. So her boyfriend left, and we heard them yelling down the street. So
I don't need to know every crime against her. What's your thing with her? Like, are you in love with her? And there's zillions of other women.
okay, it's very complicated.
It's not complicated. Is this someone you want in your life?
No.
Then why do you keep going back to her? You're addicted to her?
No, to Your Honor. She, no matter, like, I can get out and she literally have people stalk me, but then,
Sir, you're flipping the script here. You have stalking charges for stalking her. If she was stalking you, we got a prosecutor who listens and who acts on this, as you know. Why have you not gone and gotten a personal protection order, made any police reports or claims of her stalking you? And if she's stalking you.
No, I don't got a phone.
I'm sorry, you don't have a phone?
Don't have a phone.
This is America. You can use anybody's phone. It's not like we need a quarter or a dime to put in a machine anymore that might be in the corner, might not. Some people didn't have phones for many years. I lived through that time. I'm old. Right now, you can walk up to just about any person on the street, in the grocery store, walk into a business. The police agency has phones you could use. Everybody that I know would let you use a phone. You think that's a good excuse?
It's not an excuse, Your Honor.
Well, you just gave it to me. So now tell me again. You couldn't find a phone, but you could find her. And every time you found her, you assaulted her. So what is it about Ms. Mix? Are you in love with her? Do you hate her? Do you what? What's going on in your head with her?
We both hate each other. Ever since, she been, me and her been arguing ever since I was with her cousin, and not her.
Okay,
Then we end up
you
being.
still with her cousin?
No,
How about staying away from the whole mixed family? Because when you mix with them, you get in trouble.
sure.
How many days credit does he have on this probation violation file?
With, on the probation violation, one would be 126.
And does he owe any restitution on that?
No, Your Honor.
There's no restitution being sought in this, correct?
Correct, Your Honor.
Sir, as to the probation violation file, that is docket 251992 FH, your probation is revoked. As to docket 263314 FH, and as to docket 25-192 FH, you are remanded to the Michigan Department of Corrections for 18 months. I'm not doing the 24 months or more that I could do, 36 months, because you are young. But I think that being so young, having all of these charges against you, you need to really sit in prison and think about what it would be like to sit there for the rest of your life. Because this history that you have speaks to someone who will eventually be there for the rest of their life. This needs to be the last time you're in front of a judge. You need to avail yourself of the treatment that they have in prison. On the 25-1992 FH, you'll have a credit of 126 days. On 26-3314 FH, you'll have a credit of 65 days. In regard to the, I'm gonna go back to the 25-1992 FH file. You will spend, in the Michigan Department of Corrections in count 2, which is domestic violence, you will spend 18 months to 60 months. With that credit of 126 days. As to the stalking, it was a misdemeanor, he'll simply serve the 126 days with credit for 126. Going back now to the 26-3314 FH file, you will serve 18 months to 60 months. This will be concurrent with the other files, so run them together. I could run them consecutively, but I'm not going to do that either, so I'm giving you yet another break, even though you may not think that. You'll pay a crime victim's assessment in the amount of $130 and $68 state costs. Your monies on both files will be due within 24 months of your release from prison. You will participate in anger management, domestic violence, substance abuse treatment. Do you have children?
Yes,
How old are they?
5 and 3.
Your name on the birth certificate?
Yes,
And who's the mother?
first one is Lisa Lee, and second one is Alyssa Mix.
You will not have contact with Ms. Mix. Is there domestic violence against the other mother?
Yes, Your Honor.
So you will not have contact with either mother? And that means your children as well. That means they don't exist in your world, no Hallmark cards, no carrier pigeon, no Christmas presents, no flowers, no smoke signals. You will not communicate in any way, shape, or form, or I will contact the warden and everyone will have to come and see you. You will take any psychotropic medication if needed. You will also be reviewed by community mental health or whoever they have there to see what else is going on with you. I think you have ADHD, is that right?
Yes, Your
And
Honor.
you'll be able to take your ADHD meds or whatever they let you take there in regard to that, and you'll be seen by medical for that. You have any other ailments?
No, besides asthma.
And you'll be seen and treated for your asthma. What kind of work do you do, sir?
But I never had a job.
How do you support yourself? Your mom?
Yes.
Sir, your mother doesn't have to support you after 18. You got your GED. Why don't you go over to, when you get out, go over to LCC. They have the Reconnect program, you can go to college for free. You'll also avail yourself, and this is not a maybe, this is a you shall, participate in trade school. What do you want to be? You have children that you have to support. How did you intend to support them?
My first one, they both got taken when my first one got taken while I was already incarcerated.
So are your rights terminated?
Yes.
Oh, well, that's different. You don't have to pay support. So they're not your children anymore. Somebody else got to raise them. So before you have any more, get your degree, get a trade, get a job. It's not somebody else's responsibility to pay for your children or to raise them. Sir, you've just been kind of hanging out in life. We don't hang out in life.
If you think it could be serious, ask me to call emergency services or someone you know.
Well, Siri even thinks it's serious.
Good morning.
Yeah, I know. We're gonna hold Siri in contempt. I don't know why that's good then. Good job. Anyway. Have a chat with yourself. Decide where you want to be in life. If it's in a jumpsuit, that's your choice. But I believe every single person was born to greatness. Figure out what you want to be. You've never looked at someone and said, I want to drive a fire truck, I want to be a doctor, police officer, lawyer, I want to be a priest, I want to be whatever. You can be anything. Dig wells. Do whatever you want to do. Figure it out. You got some time now. If you don't figure it out, you're going to live in poverty. And I don't think that's what you want to do, is it?
No, Your Honor.
Well, then let's figure out how you can make legal money and be a taxpayer. Okay?
Yes, Your Honor.
You have 42 days to appeal to request appellate counsel. Please give Ms. appellate rights. You're now receiving your appellate rights, he needs to, because he's got one for each file.
Yes, Your Honor. To acknowledge and you received your notice of appellate rights for both files.
Yes, Your Honor.
Sir, things happen for a reason. I hope you think of this as happening for you, not to you, and you use this time wisely. And I hope that someday you come back and show me the great things that you've done. You've done all this crime. I know you can do good things in the world.
Thank you, Your Honor.
Huh?
Have a good week.
Oh, yeah.
I'm struggling today.
Yeah, it's gonna be one of those weeks. It's the end of summer, no one wants to see it go.
I killed a bunny this morning.
You killed the bunny?
I ran over it.
Oh.
I know, that's what I thought of too. Little bunny poop. Why did I do that?
Yeah, it was sad. Sad
You know,
start to my day.
Years ago, my first two were young. It was right around Easter time, and we had a cat, and it ate some baby bunnies in the yard. My kids had gone out early, went in the backyard, at sunset, and they came in crying that, the cat had eaten the Easter bunny.
Oh, no.
I will never forget that, so I just said, oh, that's not the Easter bunny, those are Easter bunny's helpers. Somebody so comes, and then we're satisfied with that, but that was really traumatic.
Yeah. Have a good day.
Oh, no.
Oh my.
They might have to grab the Bible.
So we do have,
Huh?
so we're done this morning, but, Attorney Feigelson wants to handle Mr. Treadwell right now, which is set for 1:30.
We just have to grab the file, that's okay.
Thank you, Judge. Yeah, they plead, Your Honor.
Yeah, it is a bench warrant arraignment, but it will be a plea.
I think the warrant's gonna get cleared, we can talk.
What about the evidentiary hearing, is that off?
And that's off, Your Honor, that's been rescheduled to Thursday.
And what about the, motion, Graham? Is that at 11:30?
Is that a civil?
Yeah, but no one's here for it.
Oh,
There's some.
see someone just pop up on Zoom, Your Honor.
Okay. Do we have this? What are we doing, this is a TV?
It's a bench warrant arraignment, Your Honor.
It'd be nice if I had bench warrant.
Maybe you got cleared, Your Honor. I think the issue was we had called for a hearing, and at that hearing, he wasn't here because he was in Eaton.
Lincoln County. Yes, Your Honor.
Okay. Do you have a copy of the bench warrant?
I do not, Your Honor.
Does anybody?
Yes, Your Honor.
I think Brian, Mr. Ring may have cleared it before, but I'm not certain, but
So you're here to clear the bench warrant?
yes.
All right. What do you have the date of the bench warrant?
I can pull that up briefly, Your Honor, 1 minute.
Okay. And why was it cleared?
When he couldn't have been here, Your Honor, nobody knew he was in custody.
Oh, okay, I remember somebody saying about that,
Yeah.
that should have been taken, so let's just, I'm gonna order that it be, recalled and dismissed. But we should make sure there's a date.
Yeah, I'm getting that 1 moment, Your Honor.
Did I even call this case yet?
No,
You
Your
know.
Honor.
Okay, so let me just call it and be done with it in a minute, as soon as we get the date.
So it looks as though the bench warrant was entered on April 22nd and recalled on August 11th.
Judge Mann approach.
August 11th, it was recalled, so we don't need to be.
Apparently, though, the jail still had it because he was sitting in until today.
Is there going to be a plea on this?
Yes, there
Yes,
is.
Your Honor.
Oh, okay. All right, I review and sign the paperwork. I'll get that to you in just a minute. Okay, this is docket 25-5148FH, People of the State of Michigan versus Stephen John Treadwell. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Stephen Treadwell, standing to my right today.
Thank you. Is it Stefan or Stephen?
Either or, Your Honor.
What do you prefer?
Stephen,
Okay. Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth when it comes to perjury?
yes, Your Honor.
Okay, put your hand down. Are you taking any medication yesterday or today?
No, Your
Are
Honor.
you supposed to be on medication? You're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And you had enough time to speak with your attorney?
Yes, Your Honor.
I understand there's going to be a plea today?
There is, Your Honor.
All right, thank you. On behalf, do you still live on Sandlin Drive?
I do, Your Honor.
And who do you live with?
My grandmother.
Okay, and are you gainfully employed?
Not at the moment, Your Honor, due to my incarceration in
What were
Clinton
you
County.
doing?
I'm an electrician.
Oh, okay,
Yes, ma'am.
good. On behalf of the people, what is the plea agreement?
Yes, Your Honor. The defendant we plead to an added count 3 of home invasion 3rd degree. Upon successful plea and sentencing, count 1, home invasion in the 2nd degree would be dismissed, and any restitution will be determined at the time of sentencing.
Full, fair, accurate, and complete?
Yes, Your Honor.
You waive your reading count 1, and then count 2 will be read?
Correct, Your Honor.
As the reading of count 2.
Yes, Your Honor. People of the state of Michigan versus Stephen John Treadwell, State of Michigan, County of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in an added count 2, home invasion 3rd degree, on or about August 20th, 2025, at 2803 West Michigan Avenue, Lansing, Michigan, 48912, Ingham County, State of Michigan, the defendant did break and enter or enter without permission a dwelling located at 2803 West Michigan Avenue with the intent to commit larceny over 200 but less than 1,000 therein, or while entering, present in, or exiting, did commit a larceny under 200 but more than 200 but less than 1,000, contrary to statute. This is a felony that is punishable up to a maximum of 5 years and or $2,000. Court shall order law enforcement to collect a DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, Your Honor.
So you understand count 2, home invasion, 3rd degree is punishable by 5 years and or $2,000, and you would pay restitution for any personal property damage or loss.
That's correct, Your Honor.
Looks like you signed the advice of rights form. Did you read it before you signed it?
I did, Your Honor.
Did you understand what you read?
Yes, ma'am.
And if you had any questions, your attorney was able to answer those?
Yes, ma'am.
And you're a US citizen?
Yes, Your Honor.
Did this occur while you were on probation, parole, or bond conditions?
No, Your Honor.
Sir, as to count 2, home invasion, 3rd degree, how do you plead?
Guilty, Your Honor.
And sir, do you understand that by pleading, you're giving up certain rights and defenses you would have had you had a bench trial or jury trial, such as the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense if you wanted to, the ability to remain silent, not have it used against you, etc.
Yes, Your Honor.
And that also includes automatic right of appeal. If you had a bench trial or jury trial and you were unhappy with anything, the Court of Appeals must take a look at your unhappiness, but now it becomes their decision whether or not they will take your case. Do you understand that?
Yes, Your Honor.
All right. And you made the decision to plead after you consulted with your attorney?
That's correct, Your Honor.
And you've been satisfied with your attorney?
Yes, Your Honor.
And do you understand that if you violate the law or bond conditions between now and sentencing, I don't have to follow any plea agreement or do what is recommended?
I understand, Your Honor.
The contempt. And
Yes,
the
ma'am.
contempt carries with it 93 days and or $7,500. And that does not go against the days that may be imposed under this. Do you understand that?
Yes, ma'am.
All right, very good. Has anyone told you what I will do at sentencing?
I've had,
You've gone over options,
yes, Your Honor.
but no one's made you a promise what I will do.
Correct.
Okay, because I don't know. I don't know anything
Correct.
about your case,
That's
so
correct.
I will make up my mind at the time of sentencing. Do you understand?
Yes, ma'am.
All right, very good. And sir, did this offense occur on or about August 20th, 2025
Yes, Your Honor.
in the township of Lansing County, Bingham State of Michigan,
Yes, Your Honor.
at a specific location known as 2803 West Michigan Avenue?
Yes, Your Honor.
And is that a residence where someone lives?
The person was deceased, Your Honor, to my knowledge.
Okay, but it was a home of someone.
I believe so, Your Honor.
You didn't have any right or entitlement to that property, did you?
No, Your Honor.
And did you enter it?
No, Your Honor.
You didn't go inside it at all?
No, Your Honor.
Or what
But I was
happened?
on the property, Your Honor.
So what? That is a trespass. It's not a breaking and entering or home invasion. Can somebody clear this up for me?
But,
I think I can help you, if I may.
You may.
Now, you were with one of your friends, is that correct?
Correct.
And one of your friends had advised you that he was going there to pick up some of his property, is that correct?
Correct.
And, oh, that's what he told you, your friend isn't always straight with you, is that correct?
That's correct.
And you knew that the people weren't living there, and as indicated, that person had been deceased, is that correct?
Correct.
And they had a reputation of hoarding property, is that correct?
That was not under my knowledge.
Okay, but that would have been under his knowledge, is
Yes.
that correct? Have you been to that place, have you gone to that place before?
No.
But your friend has, is that correct, or you don't know?
Yes.
And your friend went into the place and grabbed some stuff, is that correct?
Yes, he staged some stuff and then ran.
And what was your role?
Well,
as
what
a-
does that mean, sir?
But he didn't come out with anything, Your Honor.
What was your understanding of why he was going in?
Well, to get his things, but when the late person's daughter showed up, he took off. And because we arrived in my vehicle was there, and I didn't run, because I didn't know that there was.
Did you have any reason to think that he didn't have things there? I mean, he may not have always told the truth, but I don't know any human being who tells the truth all the time. Did you have reason to believe that he was going in there to do a criminal act?
Your Honor, if I can be completely transparent.
Yes, this
I
is your
wasn't-
life, not mine.
Yeah, no, and that's the thing, Your Honor, is that I at that current time, I wasn't really living my life to the best, and I wasn't really paying attention to.
That's not the question. I mean, the question really is, did you have any reason to believe, a reasonable belief, that he was going in there to get his things? Or did you have a reasonable belief that he was going in there to get somebody else's things, to sell them or what have you? What was your belief?
Both, Your Honor. I didn't really care. I was just giving him a ride. But
Did you participate in this in any way?
to give him a ride to the place, Your Honor.
Did he
And then I
tell
was
you, I'm
outside
going to take some things that, from somebody else's house that don't belong to me or do belong to me or what?
Well, he was somebody that didn't have much, so yes, I had reason to believe that it was a little sketchy. And that his intent was not pure.
My understanding is the homeowner saw you, and when they saw you, you had the property of the home in your possession, is that correct?
Yeah, Oh, yes, he had placed, an item in the rear of my truck.
Okay, now we're getting somewhere. So he put something in your truck and what was that something, a television or?
It was a guitar case, Your Honor.
Okay, and did you know whether or not he played guitar?
I don't know.
Did you believe that was his or not?
I had no knowledge, Your Honor. And wouldn't really like to call this person a friend. It was just somebody that it was an acquaintance.
So is this something you want to go to trial on, or you want to take the rap for this?
I mean, Your Honor, I'd like to get the ball rolling. I'm, after being in Clinton County, I'm ready to start, handling my business.
What are you in Clinton County for?
It was a uttering and publishing. I had done side work and got paid with a bogue check. And upon going into the credit union and attempting to cash it with my ID, they told me they weren't going to be able to cash it. And I sat there and waited for the person that gave me the check, and they never showed. And I got a warrant out of Clinton where the lady resided. And I got picked up on that.
I don't know if you're a criminal or just an overly trusting soul.
Your Honor, and honestly, an overly trusting soul and kind of an idiot at times. But I'm ready to get the ball rolling on this, Your Honor. I was told that my options would be some form of probation, and I'm not arguing with that. I can do that.
You understand you're gonna have a felony record.
Is there a way to complete probation and have that taken off?
They didn't give you that deal, but yes, there is. It's called the Clean Slate Act, so you have to wait like, I don't know, 7 years, and then you can come back and we can get rid of it. But you're gonna have 7 years with a felony.
Well, I have a trade under my belt, so I mean, I don't think that that'll hinder me too much as far as that goes, and I don't like firearms, so.
Judge, the other thing is if we were to not take the plea today, this matter would have to go back to the district court. We ran a prelim, and unbeknownst to us, the recording wasn't on. We were aware of that shortly after the prelim, but given some circumstances, for one reason or another, this is, I think, the second time we've been in front of this court, so we were unable to.
Do you want to run a prelim and see where this goes?
We already did, Your Honor.
Okay,
And the problem is the transcript got lost, and if there's gonna be a trial, that's the other rub. We now have other witnesses that, a year has passed, we don't have any of the recordings of the transcripts either. Through no fault of him or the people, Your Honor, but that's another issue we have to do.
I don't know if this should have been issued. I mean, if sir, you want to go through with it, well, on behalf of the people, do you have a police report? Is there enough here?
Yes, Your Honor, I do have a copy of the police report right here. And in the police report, it states that it doesn't state that he was in the vehicle. It stated that he was hiding behind some refrigerators in a tool crib in the south part of the yard near the vehicle. Or, 1 second. Yes, it states that he was hiding by some refrigerators in a tool crib on the yard near where the vehicle was parked. He stated that he was there because he lives in the area to the west and he said he saw 2 people come out of the area, and then he was ultimately arrested. And I believe that's when they found his items inside, the items that were stolen from the house inside of his vehicle. That is what I'm seeing, Your Honor.
Okay,
So
and does it mention a co-defendant?
It mentions, he states that there were 2 people that ran out of the residence.
Did you give police your co-defendant's name?
No, Your Honor, that's what I'm saying, that as far as I'm concerned, the acquaintances, I have no reason to believe that they even gave me their real names. Like I said, they were very quick to just leave me for the hit, so.
So what have you learned from this?
Mind my business, Your Honor, and honestly, if I was to really get hit with all of this, that I could I could lose time with my children. I could lose time
You could lose
just
time,
breathing
custody,
fresh air. Yes, yes, ma'am.
you could go to prison.
Yes, ma'am.
These are not small things.
No, they're not, Your Honor.
Don't give people rides, know your friends, they were not your friends, you see them in the back of the courtroom, no,
Absolutely not, Your Honor.
okay.
But because of my involvement, that's why I was willing to take
Okay, well, stay clean and use the clean slate act and get rid of this. I don't know what to do with this, but okay. Given all of that, on behalf of the people, any additional questions?
I guess the only thing, Your Honor, is that based off of the information that he's given, the people would be fine amending count 2 to a conspiracy to commit home invasion 3rd degree, based off of his involvement with transporting, with ultimately having the property put inside of his vehicle and then ultimately hiding when police were seen.
Because he never entered foot in there, it's a problem.
And that's why I think conspiracy to commit would be better based off the facts that he's just given to us, Your Honor.
I have no objection. I think it does fit the.
Okay, so we're amending count 2 to conspiracy to commit home invasion, 3rd degree,
Correct, Your Honor.
same 5-year.
It would still be the same exact thing, Your Honor. It would just
Right.
change it to years.
Redo the plea, sir, how do you plead to conspiracy to commit home invasion, 3rd degree?
guilty, Your Honor.
All right, and you understand the changes because you never did, the elements can't be satisfied, you never went in there, but ultimately by transporting, by dropping them off, all of that, by having an uneasy feeling about it, not driving away when they did this, or you figured out what they did, you technically are part of their bad deal.
Yes, Your Honor.
Okay. And you knew or should have known that the guitar case that was placed in your car was not owned by them, by the circumstances that you witnessed, correct?
Upon their fleeing, yes, Your Honor.
All right. On behalf of the people, any additional questions?
No, Your Honor, people are satisfied.
Nothing else on behalf of Mr. Turbo, Your Honor.
All right, our counsel, where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
This court comply with the court rule.
You have, Your Honor.
You have, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2, conspiracy to commit home invasion, 3rd degree will enter. Any outstanding warrants relating to this are hereby recalled and dismissed. And do we have a sentencing date?
September the 23rd at 11 o'clock.
Then Wednesday, Your Honor.
Yes.
Well, I make that work.
All right. And you have an Eaton County matter
Clinton County, Your Honor. I believe it's September 13th,
or? Okay.
and it should just be in and out, time served and dismissed.
Are you in lockup for that?
I've served 5 months, Your Honor, and then, so they released me once they realized how long I'd been in, and
I think he's here on that hold for the bench warrant that for lawyers that never got cleared in the jail system.
Oh, okay, so as to the bench warrant that never got cleared, as of August 11th, it is recalled and we'll note that, so you should be free to go, sir. Let's continue to report to pretrial services, okay?
yes, ma'am.
And then we'll see you September 23rd at 11. You will have to, as soon as you get released, come back here and make an appointment with probation. They're going to do a detailed pre-sentence investigation report. Just hit G on the elevator when you come in and go down to the basement there, or you can call, it's 483-6100. It's going to be on that piece of paper there.
Okay, Your Honor, you want me to do that when I'm released today?
Yes, within 24 hours, just
Okay.
call or come back here and do that, because you have to make that meeting, because we can't go to sentencing without that report, okay?
Yes,
If
Your
you have
Honor.
any questions or problems with that, call Mr. Feigelson.
Yes, Your Honor. Thank you for your time and patience, Your Honor.
All right. Thank
I'll
you.
give him my card, Mr. Phil, if you have any questions. Give me a-
All right, we're gonna give him that probation. Good luck to you, sir.
Thank you, Your Honor.
Judge, have a nice day.
Okay, we've got a civil man, we can maybe see one person. Is that this? Civil? Civil, All right, this is docket 26-137 PD GTSC Warehouse LLC versus Sasha Zuri Faith Brahman and Joshua Lee Birch. Counsel, your appearance for the record.
Your Honor, for the record, Attorney Ian Morton of Pallets Law, P67892 on behalf of GTSC Warehouse.
All right, I don't see anybody here on for defendant. Have you communicated with them?
There's been no additional communication with them, Your Honor, and no additional payments have been made.
All right, and this is your motion for execution upon the possession judgment granted.
Thank you very much, Your Honor. I do apologize for having to file the motion, but the court did add the additional 21 days, which we did honor to allow them to be able to file either an objection or hearing, so that caused the backup with the execution underneath the 28-day rule, so therefore it was necessary to file this motion.
Yeah, no problem. Sorry for the delay. You're prepared order, and that should close the case, correct?
Absolutely, Your Honor. We will submit that to the court brief.
I will look for that. Thank you. Have a good day.
Thank you, Your Honor.
Are we muted? As we're done, we just need to pause and mute. And then just when we start, just record and make sure that